Thursday, the 22nd of April 2021. This is the licensing subcommittee of the Royal Borough of Kensington and Chelsea, deciding the case of Get Here UK Limited, the address listed as Unit 11, Latimer Industrial Estate, 343 to 453 Latimer Road, W10 6RQ. My name is Greg Hammond. I'm councillor for Courtfield Ward in South Kensington. I'm one of the vice chairs of the licensing committee, and I will be chairing the hearing today. I'm very familiar with Latimer Road and the area, but I have no interest to declare. And I'm joined today by my colleague, Councillor Blakeman. If you'd like to introduce yourself, please, and make any declarations.
Yes, I'm Judith Blakeman, councillor for Notting Dale Ward. I also know Latimer Road very well, and I would like to declare that I know one of the objectors, Ms Osrin, although I have not discussed this case with her.
Thanks very much, Councillor Blakeman, and the two of us are the decision makers in this case, but we are assisted by some other people today. First of all, our legal officer, if you'd like to come on and introduce yourself, please.
Good morning, Chair. It's Heidi Titcombe here, and I am present.
Thanks very much. And then we have the licensing team, and I understand, Mr. Phelan, you're speaking today.
Thank you, Chair. Good morning. I'm present.
Thanks, Mr. Phelan. And are there any other licensing officers who need to introduce themselves this morning?
Good morning, Chair. It's Fiona Johnson.
Good morning. We have a number of technical officers from the governance team assisting us today. I won't ask them to introduce themselves. We then have responsible authorities represented today, the noise and nuisance team. Mr. Labar, I think if you'd like to come on and introduce yourself.
Yes, my name is Winston Labar. I work for the Noise and Nuisance team. I'm Area Senior Officer, and I made a representation with regard to this application.
Thanks very much, Mr. Labar. And for the applicant, I believe Mr. Nixon, I think you're representing the applicant. If you'd like to come on and introduce yourself and any members of your party who are going to be speaking today.
Good morning, Chair. Good morning, councillors. Yes, Mr. Nixon, on behalf of the applicant, I'm joined by three members of Get Here's senior team. Sana, our international legal counsel, Gavin, our site manager for Latimer Road, and Sophia, our intended DPS and also senior operations manager. I'll allow them to introduce themselves, Chair.
Thank you.
Good morning, Chair. This is Sam Reich. I'm the International Expansion Executive and Legal Counsel for Get Here. Sophia.
Thanks very much. Good morning.
Good morning, Chair. I'm Sophia. I'm the Senior Operations Associate for Get Here.
Thanks very much. Good morning. And was there a third? Is it Mr. Graham? Is it just the two of you?
Hi, sorry. There we are. My name is Gavin. I am the site manager on Latimer Road.
Okay, thanks very much indeed, Mr. Graham. Good morning to you for all the applicants. On the objector's side, I'm expecting to see, well, I've got four listed, and in the order I've got Mike Riley. Are you here, Mr. Riley?
Yes, I'm here. Can you hear me?
Yes, we can hear you. Good morning to you, sir. And
Good morning.
second on the list I've got is Gabrielle Osrin.
Yes, I'm here.
Good morning to you. And then third on my list is Anne Isabel Meyer.
Good morning. I'm attending. Thank you very much.
Good morning. And fourth on my list is Georgina Pomper.
Yes, I'm here. Thank you.
Good morning to you, Ms. Pomper. I understand you've got an appointment, a very important appointment later this morning. Yeah. What time do you need to leave your house for that?
10:15.
So I got some interference. Did you say
10:15? Yeah.
Oh, right. And I understand you're going to dial in and follow by telephone, because I won't be able to change the order of speaking if you're having to leave that early, I'm afraid. So
it shouldn't be a problem. I can go on to telephone.
All right, thank you. I've
you
got
like me to dial through on telephone when I come offline? Would that work?
Yes, it would, except that the meeting is locked, so I'll need the governance team to work on that, and they'll be noting that you're needing to dial in
okay.
At that point. So that'll be about 10:15. So I'm sure they'll be able to sort that out for you.
I mean, I can attempt to, but obviously I have to drive and everything. I can attempt to stay online. If I come across any problems, then I will obviously resort to. Is that okay?
Yes, absolutely. If you can stay online, that would be best.
Sorry, I'm in the middle of a Zoom call.
Oh, sorry. Thank you.
Mr. Riley, thank you. Okay, Ms. Pomper, so we'll try and, if you stay online, that would be great. Mr. Riley, if you could go on mute, please, because I'm hearing some background noise from you. And Ms. Osrin, you've got your electronic hand up.
Yeah, Georgina's just sent me the transcript of what she was going to say. So if there is a problem, would it be possible for me to read that out if there's a problem when it's her time to speak?
I'll have to take legal advice on that, because normally it's only registered objectors who are parties, and you're.
I'm part of the same party.
Chair, it's Heidi here. If you did you want me to comment?
Yes, I would, please. Yes, are we allowed to take a representative of an objector, or if she's part of the party, if she signed the objection, then.
Yes. So is it Miss Mayer or Miss?
No, it's Miss Osrin. It's Gabrielle Osrin that I think has joined the meeting, and I think.
Yes, she can certainly act on behalf of Miss Pomper if that's agreed, and if she wants to, she can read out the submission. That is entirely appropriate.
Yes, very good. Okay, well, that's what we'll do then. So I'm very happy with that, and thanks, Ms. Osrin, for bringing that up to our attention and sorting that out at the beginning. So that's the introductions. That should be everybody. I will just pause for a moment to see if there's anybody else in the room that feels they need to introduce themselves. Not expecting anybody, but I will pause. There aren't. So the ground rules for doing these things online, I'd ask you to keep your microphones on mute, except when you're called to speak, to prevent background noise, because that can be very distracting in an online meeting. With Microsoft Teams, it does take a lot of bandwidth, so please turn your cameras off, except when you're speaking. The chat function is not monitored. In fact, it's disabled, so that doesn't form part of the hearing. And when you're addressing us, please do speak slowly and clearly, because we will, as a panel, be taking notes while we're hearing the evidence. We've received as a panel a number of documents before the hearing, and I'll do a document check to make sure we've got all got the same things. So we've got a main bundle of papers, which irritatingly the hard copy isn't paginated, but the electronic version is, and it's 128 pages. We'll call that Exhibit 1. The next thing we received was a set of 5 photographs distributed by Mike Riley, the objector. That's Exhibit 2. We then yesterday received 3 extra documents from the applicant. There was a case summary of 22 pages, which will be Exhibit 3. We had a 2-page letter addressing the planning aspects, that's Exhibit 4. And we had a copy of what appears to be or what was said to be the text of an email from Anne Isabel Meyer to Chris Nixon of 1 page, and that's Exhibit 5. And then we had a 2-page email, or the text of an email, plus a photo from an objector who's not here today. That's Flora Herberich, and that's Exhibit 6. So those are all the extra papers that we've, and all the papers we've had. As a panel, Councillor Blakeman and I have read them in detail, so there's no need to repeat the content when you're addressing us, but please do draw our attention to relevant points when you're making your cases. So the outline proceedings for today, for those not familiar with licensing, it is a legal process, so we're following a legal format. So we're starting off with we'll start off with the licensing officer outlining the case. Then the applicants will be given 10 minutes to present their case. That'll be followed by questions, firstly from the members and then from all the other parties. We'll then repeat that process for the responsible authority, the Noise and Nuisance team, so he'll have 10 minutes to present his case, and then there'll be a question session. Then the 4 objectors will each get 10 minutes to present their cases, and obviously if Ms Osrand's reading out Ms Pompa's statement, that'll be a discrete 10 minutes, and then there'll be questions. We'll then have some discussion from the legal officer on potential conditions. We don't sum up, and we'll close the case. So before I start the meat of this, are there any other preliminary matters from any party? Please put your electronic hands up if there are. Otherwise, we'll get started. Pausing for a moment. Okay, no hands have gone up. So if I could ask Mr. Phelan, please, to outline the case this morning. Thank you.
Thank you, Chair. Good morning, all. Today's application has been submitted by Get Here UK Limited for the grant of a premises licence at Unit 11, Latimer Industrial Estate, 343 to 453 Latimer Road, W10 6RQ. Today's application is for the grant of a premises licence which seeks the sale by retail of alcohol off the premises 24 hours a day. The premises are a warehouse and dispatch centre. We understand that the premises will be inaccessible to members of the public, and all sales of alcohol will be by delivery only. A full copy of the application can be found at Appendix A on pages 12 to 22 of today's report. I can confirm that this application did attract a representation from Mr. Winston Labar, a Senior Environmental Health Officer for the Royal Borough of Kensington and Chelsea. A summary of Mr. Labar's representation can be found at pages 4 and 5 of today's papers. A further 58 representations have been received, which also oppose this application. This includes a representation from Councillor Batar. A summary of these representations can be found on pages 5 to 9, with copies attached at Appendix D on pages 26 to 95 of the main bundle. Council records indicate that Council records indicate at the time the report was written, the premises received 3 complaints over the preceding 24-month period. A summary of these complaints can be found at Appendix E, page 96. Council records also indicate that at the time of writing this report, 4 temporary event notices have been submitted over the preceding 24-month period. Finally, Miss Anna Isabel Mayer's objection was omitted from the report due to a administrative error. I can confirm that a copy of the representation can be made available on screen today. That concludes the summary of this application. I'll leave it there for now. Thank you.
Okay, thanks very much, Mr. Phelan. And I think it would be very useful to see a copy of Ms. Mayer's objection on screen, but I think we'll do that when it comes to her turn to speak as an objector later on in the proceedings. And I might need to remind that I'm going to write myself a note on that. And we'll probably have to have a little pause while we read it. There's a couple of introductory points I want to make at this point, and just particularly for those anybody who's not familiar with the licensing committee. This is a licensing application, and it means that we as a licensing committee only have the powers to determine and decide licensable activities. And in this case, that's the sale of alcohol off the premises. So regardless of any personal views we might have as a committee about the wider aspects of the applicant's proposed operating model, we can't make any decisions in the licensing subcommittee apart from those relating to the sale of alcohol. There's a very similar kind of business that went through licensing in my own ward in South Kensington a couple of months ago. And while previous cases don't create precedents, that case in South Kensington does highlight the licensing committee's powers, which include the fact that we as a licensing committee cannot stop or indeed approve or offer any decision upon the applicant's desire to offer a 24/7 grocery sales business, only to those aspects today related to the sale and distribution of alcohol off the premises. And that leads to the second introductory point to focus the minds that we have noted the statement to us from the planning department of the council that this applicant also needs planning permission to operate the proposed business model, in that they would need to change the use class of the business location to B8. We've also noted Exhibit 4, in which the applicant states disagrees with that position, but nevertheless states their intention to apply for a certificate of lawfulness to confirm that they can conduct their business without planning permission. Now, that's not something we're going to be addressing today. We can't address it as a licensing committee, but we can note that issue is being resolved and needs to be resolved in parallel to what we're doing. It's not unusual for a business to need both planning permission and a license to enable its operations, and one of them has to be done first. In this case, it's the license that's been applied for, and that's not at all unusual. I note that the planning angle must be resolved, but that is not a subject for today. So focusing on the licensable activities, it's now my opportunity to ask the applicant to make your case, please. So that's Mr. Nixon, and you've got 10 minutes to make your case.
Thank you, Chair. Thank you to the officer for their very helpful report. Thank you for confirming you have read our case summary and additional submissions, and especially thank you for the points of clarification, the 2 introductory notes. In which case, I'll try and keep it brief, Chair, because you've kind of addressed most of it there. In terms of initial introduction, I would like to clarify in terms of Getty's standard operation. That being, we are a delivery-only company with no collections from the premises. Upon an order being placed, that identifies the site in question that will form point of dispatch. That is then picked by one of our own employees, highlighted on our own bespoke app, whether age-restricted or alcohol products are included. That is then checked off against the address, that it will be a residential address. The principle that a Challenge 25 check must be carried out where alcohol is included is then communicated to the driver, who is then reminded again of the fact that they do need to carry out that check. And again, the app reminds them at point of actual delivery. I suppose it's important to point out here, councillors, the difference between a Get Here operation and any other delivery company that you might be aware of. In particular, we boast that we do not hire contractors or any such impartial or informal hiring policy. Our employees are our own, picking staff and delivery drivers. They are trained to a high standard, especially in regard to licensing objectives and the Licensing Act 2003. And we maintain our own internal waiting areas, delivery vehicles and control of such via a site manager. It's very important that the distinction be made that between another operation, Deliveroo and Uber Eats are perfect examples, and Get Here, where we are of a separate standard and we would say much better. Chair, you've already pointed out that planning and operation of non-licensed activity is not to be considered, so I won't go any further there. With the planning, I'll only touch briefly that we are satisfied we have the correct planning permissions. However, it is still being investigated, but again, I appreciate not the forum here. I will touch briefly on ABKC policy. I appreciate you have an hours policy within there. However, as pointed out in our case summary, we believe that does not apply as it does not correctly address this type of business and therefore would fall outside that. The objections, I will not go through in great detail. It's in our case summary and you've already read up there. However, it's clear there is some ill feeling between residents and Get Here. However, we maintain that we have done everything within our power that we can do within the scope of a licensing application. We have tried mediation to engage. Fiona was very kind to join us. Sadly, that didn't come to anything meaningful, but we have attempted that and would continue to do so if they are willing. But I suppose that's up to them. In terms of new material being sent through, there's some allegations there that we haven't had time to properly address. I would ask the council to be mindful of the motivation of sending these across, but especially that none of these really address licensable activity and fall back on the planning side, which shouldn't be discussed. In terms of other submitted evidence, I appreciate and have read the very early submission from Heidi and the legal services. Yes, I would welcome the opportunity to go through these as they do change things slightly and gives you yet another set of conditions. So yeah, we would like to go through those point by point, but quite simply, councillors, we are a good operator with a good application. In terms of deliveries, they will carry on regardless, and therefore I would strongly draw your attention to the two scenarios presented to you in our case summary, and that is that the premises is better for the licence. We go above and beyond what is required within the retail sale of alcohol via delivery, even so much of conditioning non-licensed activities, such as the commitment towards e-scooters, the commitment to keeping our drivers within the premises and not creating noise nuisance. Our drivers are trained to a very high level, including age verification, proxy sales, refusal of sales, and General Licensing Act regulations, which is provided by Night Trading ourselves. And therefore, we would maintain that this operation is above and beyond what the standard is expected usually. And therefore, we ask the licence be granted. I appreciate we will go through the additional conditions with legal later down the line. But otherwise, I think that's pretty clear, Chair. I'm welcoming any questions. I do have colleagues with me, including the site managers, to answer specific ones, but I'll open it to yourselves first. Thank you.
Thank you very much, Mr. Nixon. I wonder if I'll just invite Councillor Blakeman to start with the questions, but while she's preparing for that, on the potential conditions, were we minded to grant this application? That's something that we will go through in some detail, but right at the end of the hearing is the last thing that we do, and I'll ask the legal officer to go through those with you in some detail. So, Councillor Blakeman, questions.
Right, thank you, Chairman. My first question relates to your aspiration to deliver within 10 minutes. So you haven't indicated what your catchment area is for orders, and I wondered what that was.
Thank you, Councillor. In terms of the 10-minute provision, yeah, I'm aware of the marketing boast of within 10 minutes. I suppose a bit of clarification on Get Here's overall operation, as well as the intended operation at Latimer Road. The business model that Get Here operates is that we will operate a number of small dispatch points or mini warehouses, if you will, covered across the London boroughs. Therefore, we do not have massive central hubs with drivers, in the 20s and 30s going in at all times of the day. Therefore, the 10-minute provision or boast, if you will, quite simply means we have a number of different sites that operate on a small operation, if you will, that would allow us to meet that deadline. In terms of catchment area, the immediate borough of Kensington and Chelsea is the quick answer. Obviously, there is no restriction within the Licensing Act to say we cannot operate outside that. I appreciate that, but to answer your question, the immediate catchment is Kensington and Chelsea Borough.
So, given that there's a big difference, a big distance between where you're located in the south of the borough, how would you aim to achieve your 10 minutes without rushing?
Quick answer, Councillor, is we would use another site. Just because an order is made in a particular borough does not mean it will be dispatched from that exact location. As mentioned, we operate a number of small delivery hubs. Therefore, it would be the most appropriate hub that is selected. It would not mean that any order in Kensington Chelsea would necessarily come from this hub. It could be any of them. But yeah, we operate multiple different hubs, and therefore the most appropriate is selected.
So without knowing where all your other hubs are, we have to take your word for this. My next question is, how many drivers would you expect to have working between the hours of midnight and 7 a.m?
Sure. So our primary, or should I say most popular time is between 5 p.m. and 9 p.m, of which total driver capacity could reach 15, either on site or on delivery. Into the later hours, early morning and late night, it could be as few as 3 or 4. They are not particularly popular hours of day. They're important to our business, I'm sure you'd appreciate. But yes, towards the later hours and early morning, the numbers do drop substantially.
Okay, now can you tell us where your drivers would park their own personal vehicles, which they presumably have to use in order to get to your premises?
On site, Councillor.
How do you mean on site?
We have a part of land that is directly outside the premises, which we're allowed to park on. In addition, we can use the interior of the premises.
And how would you monitor this?
It's monitored and controlled by the site manager, Councillor.
Okay. So how many smokers would you expect outside your premises at any one time, and where would they smoke?
Again, this will be on the site premises, obviously outside. The number of smokers, it's a bit tricky to answer that one, Councillor, but you can assume limited to the number of drivers on site. That said, they are kept to a minimum by order of the site manager. So 1 or 2 can be fairly predictable, but mostly 1 at a time. This is strictly enforced by the site manager, by the way.
Okay. Why do you describe the employment zone in Latimer Road as an industrial estate?
That's the address given by Royal Mail, Council.
But do you understand the difference between an employment zone and an industrial estate?
Yeah, Councillor, of course, we recognise that, you know, to call this an industrial estate with residents nearby, I appreciate it may be not the most appropriate term. However, it is clearly identified as a business area. The whole strip down Latimer Road are industrial units with commercial activity going on for a very long time, to my knowledge. So I appreciate maybe not the most appropriate term for it. However, it's a bit beyond our control. That is what the area is known as.
And can you tell us how you would ensure that Challenge 25 is actually implemented on the doorstep, given that I know from personal experience that many teenagers will answer doors?
Yes, Councillor, this is again part of our training regimen where our drivers are instructed and also have the facility of the app as a reminder to carry out these checks. We are conducting and planning from sites individual spot checks to essentially test our drivers. I appreciate that the authorities will carry out their own test purchases. However, we do engage in this as well. Any driver found not to be carrying this out will face disciplinary action. Quite simply, that is what they are trained and that is what they are paid to do. So they do carry this out.
Okay, thank you, Chairman. I think these are the summary of my questions.
Thanks very much, Councillor Blakeman. I also have a few. First one's a difficult one, but I'm going to ask it and it might be difficult to answer, but I'm going to ask it anyway. What proportion of your business do you expect to be alcohol, Mr. Nixon?
Thank you, Chair. No, it's perfectly fine. I can't give exact numbers, obviously in the commercial interests. However, I can confirm alcohol lines make less than 10% of total offering of products. I'm sure you've done your own research, but you'll see that we deal primarily in commercial, consumer items that you would find in any given supermarket. Ranging from small electronics to baby products to food products, though not prepared on site. I will clarify there. So total offering is less than 10%. Actual alcohol sales translate to around 3 to 6% of total outgoings, and that is from research from previous sites and temporary event notices.
And does that proportion change depending on what time of day it is, Mr. Nixon?
Actually, it's fairly standard. The peak hours, as mentioned, is between 5 and 9 p.m. If you're alluding to the later hours seeing a higher percentage of alcohol sales, actually our findings are quite the opposite. They do seem to kind of die off towards the later hours. That doesn't mean it never happens. Of course, that's why we've applied for the licence. But usually it's peak hours between 5 and 9 p.m, Chair, that we see the majority of alcohol sales.
Okay, now we'll be going through potential conditions in some detail later on, but this one's a point of principle, and the Noise and Nuisance team propose no deliveries or collection of alcohol between midnight and 7 in the morning, and you've seen that. What do you think of that as a potential condition?
Chair, we think it's inappropriate, especially as it references soft drinks, which is non-licensable, as I know you know.
It's not what I said. I think one of the objectors may have written that, but I was talking here about alcohol specifically.
Yeah, Chair, we don't think it's appropriate. The conditions on the licence as it stands, or the application, are more than sufficient to cater for these hours. So no, we do not agree that no delivery should take place after midnight, as that will be a restriction on the hours.
We also had, I think this was from a resident objector, suggesting a prohibition between 10:30 p.m. and 8 a.m. on petrol and diesel engined vehicles. What do you? I know you described your electric bikes, but presumably you have deliveries as well. What do you say to that potential condition?
Chair, are we talking about deliveries to the premises or from the premises, or both?
To the premises in this case, because you've described from the premises in some detail.
I mean, we wouldn't, if minded to grant the licence, we won't be wholly opposed. However, I would maintain that, you know, this does concern the delivery of alcohol. Therefore, any condition restricting deliveries, I think, will be more appropriate to be restricted to alcohol as per the application. I'm mindful of a condition from Heidi received this morning that does detail that. I'm happy to discuss that condition when we get to that point, Chair.
Okay, I think I'll hold that one until we get to the detailed discussion of conditions later on. Likewise, I was going to probe at this stage on the proposal for dispersal and external management plan, but again, that's been addressed both by you and by Heidi, and therefore I think that I'll probably hold that discussion over until we get into the detail of conditions later on. And I'm just going to check my notes to see if I've got any more. Yes, one more from me. You've answered part of it to Councillor Blakeman about the protection of minors from alcohol. And we took it at the front end, which was, or the last part, which is the riders doing Challenge 25. What about the front end? How what protections are there to stop minors ordering alcohol? Can you go through that with us, please?
Sure. We are referring to the order method, Chair, correct?
Yes.
Yes. To sign up to Get Here, you have to make an account via our own bespoke designed and controlled app. That does include age verification and input of their age. Prompts are also part of the app when making a delivery. Therefore, it's highlighted at first instance, Chair.
Right, and then the next stage for a minor to interact would be at the point of the delivery to them, and you've described the Challenge 25 or your procedures for handling that already, so I don't need to go into that in further detail. So I don't have any further questions. Thank you, Mr. Nixon. I'm now going to turn to Ms. Titcombe to see if she has any questions.
Thank you, Chair. Just in terms of the policy, from a legal point of view, I know Mr. Nixon says that the midnight policy does not apply. I wouldn't agree with his submission on that. It's quite clear in paragraphs 8.8 of the our policy that what the policy is talking about is people coming and going to a premises. It's about trading, and that's specifically referred to in our policy, and it requires the applicant. It's paragraph 8.13 of the policy, where it says that disturbance is likely to follow from late trading. Any exception to the policy is only likely to be applied where the applicant can demonstrate that the new or extended license will not exacerbate the problem. So the policy does cover this situation. So I'm inviting Mr. Nixon to comment as to why an exception should be granted. This policy is also supported further by policy 12.2, which is also in the main pack, which I'm sure Mr. Nixon has. So I'm just inviting him to comment on that. So that's a matter you can consider.
Mr. Nixon, what do you say to that?
Councillors, I would disagree with Heidi respectfully. Immediately prior to 8.13 at 8.9, we are discussing customers and disbursement of customers from the premises. I appreciate maybe there is some ambiguity there, but I would point out it does not immediately or directly refer to distribution type premises. In fact, I don't believe anywhere within the policy does. The terminal hour is clearly an extension of customer disbursement that is related to earlier in the point at 8.9. So no, I'd still maintain that this type of premises falls outside of that particular policy.
Okay, thanks, Mr. Nixon, and it will be for the panel to make a decision on the interpretation of the policy, but we've heard your representation on that, and we've heard our legal officer's own interpretation. Ms. Titcombe, do you have any further questions for the applicant?
No further questions at this stage. I'll deal with the conditions at the conditions section. Thank you.
Thank you very much. Now, responsible authorities, Mr. Labar, do you have any questions for the applicant?
Not at the moment. I was going to deal with it later when we were going over the conditions that Heidi has suggested, if that's okay.
Yeah, I'm going to give you your chance to make your case presently anyway. So I'm now going to turn to the 4 objectors, and this is an opportunity for the 4 of you to ask questions of the applicant. It's not an opportunity to comment on the case or make any statements, because you get that opportunity later on in the proceedings. But if you do have any questions of clarification that you wish to put to Mr. Nixon, now is the opportunity. And can I suggest you use your electronic hands so I can see if any of you wish to. So we've got a first hand from Ms. Meyer. So Ms. Meyer, your question, please.
Good morning again. Yes, my question is, on one of the pictures, or you always say it's e-bikes, but in order for your delivery drivers to get there, they have to have a transport. And on one of the pictures, it basically shows there are 5 or 6 normal noisy bikes standing, which means coming and going at the beginning and end of a shift, and perhaps just doing their own in between, will really disrupt the area. Can you comment on that, Chris?
Mr. Nixon.
Thank you, Anna. Yeah, I can confirm that all deliveries from the premises are carried out using our e-scooters. The motorised vehicles alluded to are not used for deliveries at any point and do show the vehicles used for staff going to the premises. Councillors, I'd point out that the vehicles used for drivers coming to the premises would fall outside of the boundaries of any given licence. But again, I would allude to the two scenarios within our case summary. It's not for a licence to dictate how people get to work. That would be inappropriate. And regardless of any licence would be carried out anyway.
But to grant a licence...
Miss Mayor, we need to finish hear the rest of the answer. I'll call you back in a moment for a supplementary.
Thank you, Chair. I was about to finish there anyway. It's not appropriate for a licence to cover non-licensable activities, especially of this type, dictating what people can or cannot use to get to work.
Ms. Meyer, do you have any further questions?
But in order to, to use the license, you have to make, sorry, I'm German. You have to make, not amendments, have you make ways of dealing with your employees, and part of them is getting to the premises. And if you have 8 bikes or 6 bikes in this picture parked outside, it should be part of the license. Not to agree, but it shows that the license is not functional, or your search of a license is not working. Thank you.
Mr. Nixon, do you want to come back on that one, please, and give us your answer?
Same comment as before, Chair. It would be inappropriate to condition or try and amend a licence far beyond the scope of the licensable activities. Journeys to work, it's not appropriate to cover here.
Mr. Meyer, do you have any further questions?
I could no further questions, but I totally disagree.
Yeah, you'll have a chance to comment later on, but that's
okay.
That's fine. Okay,
Thank you.
No further questions. So, Mr. Riley, your hand is up. So, if you'd like to unmute yourself and ask your question, please. Mr. Riley, please unmute yourself. I see your hand is up. There we are.
I'm unmuted now.
You are, yes. Please go ahead.
Yeah, those bikes are from Papa John's and Domino's Pizzas deliveries. They're moonlighting on working for Geteers. I'd like to take a chat with Chris Nixon regarding he's gone to great lengths to state that their drivers are trained to a high standard above everyone else. If you go online, which I there is. There is. If you go online, all that's required is a provisional license and a CBT, compulsory basic training. I'd like to actually know how many of the riders have an actual full license.
So, Mr. Nixon, numbers and proportion, please.
Sure, Chair, can I point this question to our site manager, Gavin, to go into a little more detail about the drivers at this particular site? Gavin, could you just give some brief detail? I appreciate I'm not asking you to go into employment contracts or anything like that, but to confirm the use of e-scooters for deliveries. There are no moonlighting, third-party drivers or anything of that nature, and that they are fully licensed drivers.
Yep, of course. Thank you, everyone. All of our drivers are using their e-scooters, where they have passed all of the relevant and legally required abilities to do so. In regards to their bikes wherein they're moonlighting, a lot of them have purchased their bikes from their own personal bikes from ex-suppliers. So yes, some of them do have advertising boxes on the back. That one there, I believe, is a travel box in that photo. But yes, all of our drivers have passed all of the relevant requirements for them to be able to ride our e-scooters.
Thank you, Gavin.
Thanks very much. And it is, Mr. Riley, do you have any further questions?
Yeah, he's avoided how many actually have a full license to operate in the street.
So let's try that one. How many or what proportion have a full license?
I think it was clear there, Chair. All of them have full licenses.
Okay, thank you very much. So, Ms. Pomper, I see your hand is up. So, your question, please.
Yes, indeed. From what I've seen from all the numerous bikes, that picture doesn't even quite show how many bikes are usually parked outside. All of the bikes have learner plates on them. From when I looked into what Getier's requirements are, I think there's just a very basic perfunctory. As long as you're over age 18, you do some tiny course. I'm not sure quite what it is, but this is not a, I think it's a very far claim to say that these are very experienced and very different riders. And considering that...
Are you turning this into a question, Ms. Pomper?
Yes, so the question is, if they're driving other bikes, again, their own bikes, which are not electric bikes turning up at the premises, also with learner plates, I'd like to know at what experience these apparently very experienced bike riders are at. Thank you.
Okay, so the experience level of the bike riders, please, Mr. Nixon.
Thank you, Chair. If I might point out, we are drifting quite far from the actual application here. We're now getting into what delivery drivers have in terms of licenses. This is an alcohol license, not a driving license. I'm happy to comment,
Mr. Nixon.
Chair, but we
Yes,
are drifting quite far here.
Yeah, Mr. Nixon, I do need you to comment because the alcohol would be distributed by the bikes. So I do want to know the answer to this question. Please go ahead.
Fine. The drivers have all the necessary licenses in order to operate the vehicles that we utilise for deliveries. That's covered by other UK law, and they have exactly that. In terms of experience, the training related to, we're talking about the distribution, or so to say, the supply of alcohol. They are trained to a very high standard in that regard. In returns to actual driving, they comply with all necessary UK law, Chair.
Thank you, Mr. Nixon. Ms. Pomper, do you have another question? And it does need to be a question, not a comment on what
Apologies. Yes, indeed. It hasn't really addressed my question whether the bikes that they use, both for Getier and also for arriving at work, all bear learner plates. Thank you.
So learner plates, what does that symbolise, Mr. Nixon?
Gavin, could you chip in quickly here just to clarify again that our drivers do have the necessary licenses to operate the vehicles?
Yep, absolutely no problems. First point, somebody mentioned 18 years old. All of our drivers are over the age of 21. They all have all the necessary requirements to ride their bikes. Lots of their CBTs have been going on for, they've redone them over several times. They've all been on bikes for a prolonged period of time and all are over the age of 21.
Thank you, Gavin.
Thank you, Ms. Pomper. Do you have any further questions? You'll get the opportunity to comment later on, of course.
Yes. Yes, another question. Apologies. On Getier's own hiring pages that have been online, they have requested that drivers are over the age of 18. I'm surprised to hear that they're over the age of 21. Can we please confirm that?
Gavin, could you reconfirm for Georgina, please, that the drivers currently are all over the 21 and none of the drivers are under 18?
I can confirm that every single Getier e-scooter rider is over the age of 21.
Yeah, and I could go on and ask for whether you would take one that's between 18 and 21, but I don't think that's relevant to licensing. So, Ms. Pomper, do you have any further questions?
No, that's fine. Thank you so much.
Okay, no problem. Thank you very much. So I'll just pause for a moment to see if there's any further questions from the objector side, but I'm not seeing any more hands up. So I just have a couple of follow-ups on that. I noticed, Mr. Nixon, you described some ill feeling with the residents, and you've had some meetings with them. Would you be willing, in principle, to have a condition that requires periodic meetings between the company and residents?
Joe, we would be amiable and very happy to condition meeting with the residents. even though conversations might not have resulted in anything particularly direct here, we would be very open and happy to condition the licence to commit to such meetings.
Would you also be willing to have a condition on the number of smokers outside at any one time?
If minded to grant the licence, yes, Chair, we will be happy.
Yeah, obviously all conditions are, I mean, we are dependent on granting the licence, because if we refuse it, all the conditions fall away. But if we grant it, you would be willing to have a limit on smokers?
If minded to, Chair, yes, of course we would.
Okay. Thank you. I'll just turn to Councillor Blakeman and see if she has any questions arising before we move on to the next stage.
No, I don't, but I think Mr. Riley may have a
Oh, yes, he's just put his hand up. Mr. Riley.
Yeah, hello, can you hear me?
Yes, go ahead.
Yeah, we've had 2 meetings with Chris Nixon, whereupon we gave him our concerns, our fears, and our evidence of misappropriate behaviour. And as of yet, Mr. Nixon has done nothing about it.
So I'm asking for a question, not a comment.
Well, if he agrees to these meetings, will he actually action things we represent to him?
Mr. Nixon.
Yes, of course, Chair. I appreciate that any subsequent meetings would inevitably cover potential things outside of the scope of the licence. But yes, of course we would. In terms of doing nothing, Chair, I mean, there's little I can do outside the scope of the application. However, if meetings are conducted, of course, senior members of Get Here, including the site managers and employees, would be invited to attend. Any and all concerns raised would be actioned upon. So, yes.
Okay, thanks very much, Mr. Nixon. I'm not seeing any further hands. So in which case, we're moving on to the next stage of the hearing, which is the responsible authority.
Chair, sorry, it's Heidi Titcombe.
Heidi.
Can I just ask one question? Because you raised the issue about smokers, I just wondered if Mr. Nixon could identify if there is a smoking area within the curtilage of the premises, or whether it's on the street or whereabouts it is.
Thank you, Heidi. Gavin, you probably are best placed to answer this one, but my understanding is directly outside the premises, but within the boundary of the premises itself. Could you confirm that, please, mate?
Thank you all. Yes, I can confirm that they are smoking outside of the building, but within the bounds of the premises. If we all saw the indication of where the motorbikes were parked on our premises, it's towards there.
And can you confirm that this is tightly controlled by yourself as the site manager and also the senior Get Here staff?
Yes, the team are all aware. We send out a weekly message to them, reminding them of their where they can, where they can't do smoking, and numerous of are taking breaks, etc., etc.
Thank you, Gavin.
Ms. Titcombe, do you have any further follow-ups to that as a question?
No, thank you. That's helpful. Thank you.
Okay, thanks very much to Mr. Nixon and your party. I'm now going to turn to Mr. Labar to present the case for the responsible authorities. So, Mr. Labar, if you'd like to come on line, and you have 10 minutes to present your case, followed by questions.
Yes, thank you, Chair. Yeah, my concerns in regard to this applications are solely to do with the prevention of public nuisance and the fact that if they would like 24-hour operations, it can lead to disturbance, i.e. public nuisance, especially after the terminal hour of midnight. And my reading of the licensing policy states that in order to maintain a balance between commercial and residential interests, such that residents can enjoy the peace and quiet of their homes, the licensing policy generally would like commercial interests to cease trading around midnight to stop or prevent the, how can I say, the public nuisance condition being, how can I say, being caused problems, being problematic. So that's why I put my objections in, and also I didn't believe that what I read from the statement that they put in, that they had adequately dealt with the public nuisance objective, in as much as background noise levels fall later into the night, noises, impact noises such as vehicles and people speaking and various other things like this, especially if the residence or the premises opposite residential premises can disturb local residents. And I just wanted to ensure that the steps that they are taking or will stop this from happening moving forward. It's a very reverberant street. I'm very well aware of the area. There are other, how can I say, commercial interests in that area, and there's been a lot of impact in the past. So I do, as a result of activities that have gone beyond midnight. So I'm, very aware of the problems that have occurred in that street. I'm not trying to put them all onto Getir, but I don't think Getir has adequately addressed the prevention of public nuisance objective in their submission.
The panel are reassembling now, and I will just wait for governance before we restart.
I think I'm here, have I?
You are, Judith, yes.
Yes, and it's Anne, Chairman. I'm here, and I believe I can see everybody still logged on. Let's just check with the main parties. Is Chris Nixon back at his computer? Because I know he was taking a 5-minute break.
Yes, and all the applicants are still present.
Super, thank you. And the objectors?
Yes, I'm here.
Gabrielle, thank you.
Yes, Anna is here.
Super, thank you.
Mike
Tom?
Riley's here.
Super, thank you. And Mr. Labar, are you with us, Winston? Winston, are you back with us?
He's muted.
I just wanted to check he hasn't left his computer for a few minutes. So let's just wait till Mr. Labar confirms he's back.
Well, as we're about to ask him questions, we're not going to get very far without him. So, yes, please text him and make sure he's back, and then we'll resume when we've got him.
Thank you. Sorry, Winston, can you confirm that you're back in the meeting with us? If you possibly unmute, if you're on mute. Chairman, I have sent him a message, so hopefully he'll be with us shortly.
Thank you, Anne.
Chairman, can we just try again? Mr. Labar, are you with us? Winston, can you confirm that you can hear us?
Yes, I am.
Super, thank you, Winston. Tom, can you confirm that you're ready with the live stream, please? Yes, Chairman, I can confirm we are now live. It's Anne from Governance.
Okay, thank you very much. And with apologies to everybody for the technical delay there, we're now going to resume the hearing of Getir at 11:12. We're at stage 2, which is the case for the responsible authorities, noise and nuisance, and we're just about to start questions for Mr. Labar. So, Councillor Blakeman.
Yes, thank you, Chairman. I just wanted to ask Mr. Labar if he could tell us something about the Section 60 notice that has been served.
Sorry, I'm unaware of a Section 60 notice being served on that premises. Section 60 notices are for normally for construction sites, Councillor. Therefore, noise in regard to hours of works on construction sites. I'm not aware of one being served on this company.
Sorry, it was mentioned in the papers, but if it's construction, presumably that is over and finished?
As far as I'm aware, as I said, I'm not aware of any construction that's been going on there that would have required a notice.
Okay.
Any further questions, Councillor Blakeman?
No, thank you.
Okay, that was my question as well, was the Section 60. So I'm not sure who's going to be able to resolve that for us now. So we might, next time we adjourn, pursue that one and see if there's a way of getting an answer to the question if Mr. Labar can't to help us. So I don't have any further questions for you, Mr. Labar, but I'm going to ask Ms. Titcombe if she has anything she wishes to ask.
No, not at this stage. I'm just wondering if the applicant could help us about the Section 60 notice, if they're aware of a notice being served.
Well, I think that's a good idea because it's the applicant's turn to ask questions anyway, if he wishes to. So, Mr. Nixon, maybe you can enlighten us on your views on what you know about the Section 60.
Thank you, Chair. No, I'm not aware of any Section 60 being served to the premises.
Okay, that was brief then. So, Mr. Nixon, do you have any questions to ask of Mr. Labar?
I believe just the one, Chair. Winston, just following up from the question from the Chair there, you're maintaining that an alcohol licence will effectively make the premises more noisy than if it was delivering any non-licensable products. I appreciate and note the absence of any primary evidence being served for this, but I'm wondering if you could verbally explain to the councillors how a delivery of alcohol would be louder or cause more nuisance, or any nuisance for that matter, than a non-licensable product.
Yes, thank you, Mr. Nixon. Again, I was just alluding to the fact that you can have licensable, non-licensable products being sold or collected after midnight, just as you can have alcohol. But it's for me, it centers around the fact that the hours of midnight to 7 in the morning are normally the hours when people try to, how can I say, rest and recuperate before moving forward into the next day and everything else. And these are the times when disturbances have its greatest effect as noise levels fall. So the more activity there is as a result of goings and comings to the premises would potentially increase the, how can I say, potential for public disturbance, depending on the level of activity that's going to be, how successful your business is. But as I said, my whole sort of remit is trying to limit the, how can I say, public nuisance objective being, how can I say, or try to stop the prevention of public nuisance. So that's the only reasons why I've put my conditions forward. It's possibly that it may not have any impact in that the delivery of alcohol will have just as much disturbance or the same disturbance as or the collection of as non-alcoholic goods.
Thank you, Mr. Labar. Mr. Nixon, do you have any further questions or follow-up questions?
No, I think Winston's answered in a roundabout way there that he would agree that a licensable product would make no difference to a non-licensable product, and that this question of the later hours is more suited to, I expect, planning rather than licensing. No further questions at this time, Chair.
Thanks, Mr. Nixon. I don't think that's quite what he said, but I think it's time for the objectors to. Ms. Tickham, please come in.
Yes, thank you, Chair. I was just going to clarify. I wouldn't agree with what Mr. Nixon said there. Mr. Nixon is characterising the public nuisance in terms of products, but that's not the case. Public nuisance occurs because of activities in and around licensed premises. The fact that the premises may be able to operate now without any conditions is irrelevant in a sense, is because it can't be controlled. But if you are applying for an alcohol license, then that's when the statement of licensing policy and the licensing objectives do become engaged. And as I was understanding Mr. Labar's representation, it's because later in the evening, if there's activity around a premises, that can cause public nuisance because it disturbs sleep. And I think that's the point he was making, which is covered in the midnight policy, in the council statement of midnight policy.
Thank you, Ms. Tickham. It was also my understanding that Mr. Labar was talking about the volume of movements overnight, some of which would be licensable and some of which wouldn't. Let's move on to the objectors and see if the objectors would like to ask any questions of Mr. Labar. And once again, I'll invite you to put your electronic hands up if you do. I'm just going to pause for a moment to see if anybody wants to ask a question. And I'm going to say, oh yes, we've got one. So Ms. Meyer.
Yes, sorry, don't know if it's to Mr. Labar or General. Section 60, what is this? Sorry, you.
I think it was explained to us as a prevention of noise from construction noise, and we weren't able to establish from the earlier evidence whether there had been any construction.
What 60 is, that's all.
Yeah, sorry to interrupt, Chair. Section 60 of the Control of Pollution Act is 1974, is an act laid down Parliament whereby local authorities can control the noisy activities of construction sites by limiting the hours in which they work, and also asking them to use best practicable means to minimize noise that's disturbing local residents. And we limit the hours by ensuring that they only do noisy works between 8 and 6 Monday to Friday, not on a Saturday or a Sunday when local residents are trying to enjoy their weekend and a respite. So that in essence is the basics of a Section 60 notice.
Thank you very much, Mr. Labar. And I know we've established what it is, and while we would have liked to have known the specifics for Get Here, it's not actually relevant to licensing. So the fact that we don't know precisely what happened on the 6th of April is not going to change our conclusions from this hearing. So, Ms. Mayor, do you have any further questions to ask of Mr. Labar?
Not at the moment, thank you.
Okay, no problem. Mr. Phelan has your hand up. Maybe you can help us with this.
Thank you, Chair. I can indeed. I can clarify the timeline and what actions were taken. So on the 6th of April, a noise officer requested that a Section 60 notice be served on the company's secretary, DESA Limited. However, they did communicate with that officer as recently as the 13th and 14th of April. The officer has instructed the notice to be withdrawn as it's materialised that DESA Limited is not the company that was responsible for the construction works. That's a brief timeline of the events surrounding the Section 60 notice that was served in relation to this premises.
All right, that's very helpful, Mr. Phelan. It's not a licensing matter, but it's helpful to know that as background. Okay, well, in which case we've come to the end of the case for the responsible authorities. We now move to the third stage, which is the case for the objectors. So in a moment, I'm going to invite each of you to present for up to 10 minutes. And then we'll go into a question session for all of you. So I don't know which of you wishes to present first. I don't have an order, so hands up, and well, I see Miss Meyer, you've got your hand up. If that's agreeable to everybody else, you can go ahead, and you've got 10 minutes.
Okay, thank you very much, Chair. Firstly, we thought we had 10 minutes altogether, so we just really comprised our information, but it's great to know we have time and can speak our soul. So I received my confirmation email about my objection, but I can't find my name and my comments on the list. You mentioned there was something.
Indeed, yes, and I thank you for reminding me. So your objection has just been put up on the screen. So if we could just scroll.
Hello, I have a question. Hello, I have a quick question.
Mr. Riley, I'm not into questions here. We're into Ms. Meyer's statement. So if we could just scroll down the screen, please, so we can see the whole objection. Because I can only read part of it at the moment.
Oh.
It needs to be perhaps a bit bigger than that. Yeah. And I'm not counting your 10 minutes at the moment, Ms. Meyer. So if we could just pause for a moment and we'll get the chance so I can read what you've written. No, I've read it, but I'm just going to pause for a moment or so to make sure that Councillor Blakeman's also read it.
Yes, I have.
Okay, thanks. And is there only the one page for governance? You don't have to look at a second page. It looks like it's finished. Oh, there we are. Yes. Okay. So we've read your objection, Ms. Meyer, and I'll now invite you to start your 10 minutes.
Great. So after we had a couple of meetings with Chris, and after the second one where we had a bit of a stalemate and just didn't go anywhere, I sent an email which I would like to read out. Dear Chris, thank you very much for your time last Wednesday. Firstly, we would like to clarify that you are employed by Getir. Your role is not to mediate, but just to answer licenses questions. Because it always felt like, oh, he was doing us a favor. No, it wasn't. It's just answering our questions. During our 2 meetings, it became apparent that the premises have no approved change of use to be made, and therefore any further talk about licensing becomes airy-fairy. Because I don't understand why talking about license, which is the icing on the cake, if the basics are not established. Also considering the number of objections received, it must have become clear that the business enterprise and utilization of Unit 11 is not compatible with the residential character of Latimer Road. In order to prevent wasting our and the council's time, we therefore suggest you go back to your client and advise Mr. Getir to withdraw the application until the planning issue has been resolved. Best wishes, Anna. So I was hoping they would take it to heart and dealing with the planning application first, and then we would meet and have the few points which needs to be clarified, discussed. Another few points in the 22-page summary I received, the objections, the contents of the objections are listed, and it always more than half of them is saying there's nothing in whoever's it was representation that has not already been covered above. And what I would strongly mention is that means the points are really valid if they're getting picked up by so many people. 58 plus mine plus another person I told us he wasn't on the list. So it's not just like a little inconvenience, it's a change of the area. It is in the way it is constructed, or it is said, is patronizing and very dismissive. Then points 12 and 13, it is also worth pointing out that this application has not attracted representations from the police and the licensing authorities. By not representing the matter, it doesn't mean the police and licensing authorities are happy with the matter. They're just probably overwhelmed with other things. And having alcohol sold in the area or in a 10-minute radius of the area, it just will increase all their problems. And I really strongly wish the panel will dismiss this this application and will postpone this application until the licensing, until the planning is established. Thank you.
Okay, thanks very much, Ms. Meyer. We'll come to questions presently, but I'd like to see who'd like to go next. Ms. Osrin. Ms. Osrin, your hand is up, so please come online.
Hello, yes, I've unmuted. So thank you for the opportunity to speak. As this is licensing, I'm not going to go into the spurious sort of refutations that were made towards my objection, i.e. mentioning a truck was idling for over an hour, and Mr. Nixon suggested, well, it doesn't specify it was a Getir truck. I don't think I would have put it in my objection if it didn't relate to this particular situation. I really want to talk about public nuisance. I feel that during this meeting, Mr. Nixon's been comparing Getir to companies like Deliveroo, etc., and that's not really comparing like with like. There are many similar businesses already operating in the area. I got a leaflet through my door yesterday for one of their competitors, Zap Delivers, and it does groceries, but the main picture on one side is solely bottles of alcohol, although admittedly there is playing cards, tonic and a lime as well. And the voucher code is party on one. And I think it's clear that whatever Getir's international operations might detail, there will be more orders throughout the night for alcohol than for groceries. You know, that's what will be ordered in RBKC. It's not people who've forgotten to get any milk. So I think it will increase out of hours noise and public nuisance and hazards to public safety. I've looked at some of their competitors, so this might be what Councillor Hammond referred to before, that Wheezy, which is operating from an existing shop front, is only delivering between 10 a.m. and 12 a.m. You know, it's been suggested that Getir will operate with or without a licence, but with all the competition in this new and sort of boom industry of quick deliveries, I believe the 24-hour model is reliant on alcohol sales. So I think it's disingenuous to say they will just operate with or without. Mr. Nixon also cited the irrelevance of my concern that the granting of this licence sets a precedent. There has to be joined up thinking as to how RBKC issues 24-hour licences, which continue to be held by the site even when the company is gone. I understand that this decision will be made solely on this application, but at the same time, it cannot be made in total isolation. There are many offices, small businesses well integrated into RBKC's residential streets. Will the RBKC licensing policy as it exists be ineffective in preventing any of these becoming 24-hour alcohol distribution facilities for the many companies competing for such sites? And if so, how will the council represent its residents in the future? The Licensing Act states that licensing authorities must keep their policies under review, make such revision to it whenever relevant. And perhaps now is the time to consider how these new businesses will be successfully integrated into the borough without damaging many residents' basic rights and upholding RBKC's constitution. In the mention of the app covering sale of alcohol to minors, that does cover Gettier, but it doesn't stop the sale of alcohol to minors. As we well know, anyone could sign up to the app and in effect, their signing up and lying about their age covers Gettier for not supplying alcohol to minors. That's what happens in local shops when kids go in with fake IDs. The shops are able to sell them alcohol because they have been shown a fake ID, or that seems to be the case. In terms of meeting up and collaborating with Gettier, in our first discussion, Mr. Nixon spoke confidently about setting up meetings every 3 months in the future to discuss this further, as if this was a generous offer to engage with the community. He told us basically what was happening and implied that the licence would be granted. Now, I'm not a forensic linguist, but his use of language at that stage suggested that Mr. Nixon was presuming the granting of a licence rather than discussing the granting of a licence and the concerns of the community. It wasn't community engagement. Similarly, his statement that this is a good application by an applicant that is experienced in operating and who does operate in these types of locations omits the fact he has not seen this location, and we have no evidence of other Gettier distribution centres operating in residential streets. Gettier have failed to acknowledge the unsuitable nature of their chosen site. Why should we pay for their lack of due diligence in their location department? 1 block away, on Mitre Way or nearby on Scrubs Lane or Ariel Way, there are vacant industrial units of similar size that would have provoked no opposition to licensing. It's important to ask, why twist an unsuitable location to fit their business needs rather than use a readily available and appropriate location where licensing would not be an issue? In short, I'm not opposed to Gettier's business model and 24-hour licensing. I'm opposed to its being granted on a residential street. And Gettier can sincerely state their objectives to mitigate public nuisance if a licence is granted. But we all know it's up to residents to police them, film, record, photograph and make repeated and timely complaints if they're broken. This is a lot to ask of hard-working residents on a daily and nightly basis. And our current experience seems to suggest that the entire street would need to be clearly informed about using the same chain of complaint once established. A task that no doubt will fall to residents to organise, because if complaints are made to different places, they may not be collated. And in terms of the licensing policy, Gettier criticises the repetition of objections and criticised my own cutting and pasting of RBKC's licensing policy, but they themselves have cut and pasted the same licensing application to other boroughs in London. There's clearly not been any consideration of the Royal Borough of Kensington and Chelsea Council licensing policy, which is to not grant applications with closing times after midnight, in Gettier's attempt to ensure the promotion of the 4 licensing objectives. Section 8, item 13 of RBKC's licensing policy states, as Winston has said, that in this particular borough, disturbance is likely to follow from late trading. Any exception to the policy is only likely to be applied where the applicant can demonstrate that the new or extended licence will not exacerbate the problem. This licence will exacerbate the problem, as at present, there is no problem with disturbances by late trading except by Gettier's operations. The granting of the licence will create a new problem by generating all-night alcohol deliveries. And it's all very well to Gettier to claim that this policy does not apply to them because they are a different sort of business. But there's no wording that explicitly states this policy does not apply to their business. It talks about scenarios, but it is not limited to them. The law is open to interpretation. It's not a straightforward tick box exercise, which is exactly why we're here, taking time out of our working days. This is not our jobs to be doing this. This is not our elected responsibility to do this. I'm taking time out of my working day, out of my comfort zone to make an objection. And I presume that the councillors, our elected representatives, will make their judgment accordingly, regardless of what Getir seems to think. And you know, does this application work within the terms of the borough's own licensing policy? I believe it does not.
I'm guessing you drew to a conclusion there, Miss Osrin. You were within.
Yes, that is the end. Sorry.
Thank
you. We had thought it was 10 minutes between all of us, so
you're
over, going to be brief.
Yes, you're well over 10 minutes between you, but you were 8 minutes there, so that's good, and you made the point. So, Mr. Riley, you've got 10 minutes now, and your hand is up. So please do go ahead.
Can you hear me?
We can. Go
Can
ahead.
you all hear me? Yeah, great. Sorry, yeah. I did have a question for Winston earlier on, but I'll bring it to your attention now, Mike, as well. I think we need to be asking what types of people would be ordering alcohol in these wee hours of the morning. I mean, as the chair's probably aware, there are an awful lot of illegal parties, all-night parties, blighting the borough at present. And it is companies such as Getir who are fueling these parties. I just thought I might say that. Since Getir have moved in, and this is bearing in mind that it's effectively a honeymoon period, this business has shown zero empathy for our streets, zero empathy for our road users, zero empathy for pedestrians, inclusive of children. Chris Knight went on and saying that he's addressed each and every complaint, but he has, as I mentioned earlier, brushed aside our 2 meetings with him, which was obviously witnessed by 2 members of their party. Since their instalment, even Montague Evans have gone on to list about how concerning the drivers are, etc. But that's just a cut and paste job, quite frankly, from the applications they've submitted to Lambeth, Camden and Brent, and possibly a few more. They're going on about how thoughtful the drivers are and how considerate they are, etc., and what a great company Getir are. But we have documented evidence that directly is breaches of the licensing agreement. We've got photos, videos, emails, and complaints. There have been 3 dangerous driving on 3 occasions. 2 I reported directly to Getir, and as of today, still heard nothing. 1 was an incident that happened on a Sunday where the courier pulled out of the Getir depot and caused the car to take evasive action. This was followed by an altercation and a weapon was produced and the police were called. And that's a clear breach of licence. That's crime and disorder, breach of public safety. We have dust carts late at night, with overflowing dust carts, I might add, which is a breach of noise. Again, that's a breach of licensing agreement. The couriers, lots of couriers, we have photographic evidence, blocking pavements and smoking. Breach of protection of children, that's a route to nearby school, noise dampening. We also have delivery lorries with engines still running all hours of the evening, clear breach, noise and pollution. The pallets that are blocking the pavements, again, clear breach. That's a danger to pedestrians, school children, partially impaired people and blind persons. So, I mean, all in all, what we're actually asking is that please, as our council, please do not grant this license, because all it will do if it's granted is it will blight our neighbourhood. The situation will only get worse. Thank you for your time.
Thanks very much, Mr. Riley. Now, Georgina Pomper, I know she is out and about and may not be able to speak to us.
No, I'm actually here.
You're back.
Here.
Excellent. And are you able to address us? You've got up to 10 minutes.
Yes, indeed.
Oh, great.
Okay, so thank you very much, everybody, for being here today. I have to say, I find Getir's submissions worryingly cavalier. There's been in excess of 58, possibly 60, if not more, original objections, alongside copious, serious noise and nuisance and safety complaints submitted during what we believe is their honeymoon period. These have been timed, dated, and evidenced. The fact is that Getir has opted here, and obviously for reasons unknown, for a largely inhabited residential street without necessary B8 planning licence, and has clearly shown that they are unable to abide by the 4 licensing objectives on a consistent basis, and not just with the reference to sale of alcohol. Further, Gateer's submissions demonstrate that they're unwilling to meet the minimum required threshold of a licence. Legitimate concerns raised, albeit by a senior officer in the licensing, noise and nuisance team, have been dismissed with the same ease as that of affected residents, all of which have been referred to somehow as repetitious. What is repetitious here is that Gateer's serious and flagrant abuse of the 4 licensing objectives. I quote from a recent email that I sent to Noise and Nuisance team last week. On Tuesday at 12 p.m, my elderly mother came to pay a visit. As she was cautiously crossing the road, a Gateer bike silently zoomed past and almost hit her. Last week again, whilst walking my dog on the pavement, a Gateer bike reversed across the pavement, again almost hitting and frightening my dog. This speaks volumes about Gateer's disregard over very serious breaches of licensing objectives. Almost finally, it appears that Gateer now have expanded their executive car parking into Unit 10's neighbouring premises. Do they have an agreement with Unit 10 for such? And are they now planning on expanding into 2 units on Latimer, having already clearly outgrown Unit 11? Finally, in a meeting organised with RBKC licensing team, Chris Nixon claimed that the licence for the sale of alcohol only represented 3 to 4% of Gateer's business. That being the case, one can only assume that given this negligible amount, Gateer doesn't in fact need to get a licence granted to them at all. Thank you.
Thanks very much, Ms. Pomper. We'll now turn to members to see if they've got any questions for the applicants. Sorry, for the objectors, my apologies. And starting with the members, and we will confine the questions to those matters which relate to licensing. So I'd just like to start with the condition that was suggested, and obviously the wording might be a matter for debate, but Noise and Nuisance proposed, Mr. Labar proposed a condition on no deliveries or collection of alcohol between midnight and 7 in the morning. Would those, so for the 4 of you, and would those times make it more acceptable to grant the licence for the rest of the time for alcohol? What do you think?
Me personally, I wish it was moved forward to 11 p.m. would be much better.
But you would be happy with the licence for alcohol distribution up till 11 p.m, Mr. Riley?
Up to 11 p.m, I think within licence. I'm speaking out of turn here where we don't know, but anything to stop this mess in the middle of the night.
Right. I mean, there are 58 of you, and you can only speak for yourself. So I'm quite happy to listen to your views. Also, interested to hear what. Well, I'll ask you individually. So, Ms. Pomper, what do you think about allowing alcohol deliveries and sale and distribution, but stopping at midnight and starting at 7 in the morning?
I believe it's far too late. I'm sorry, on the 4 licensing objectives, there is already, as I said, breaches in all of the areas, and the amount of noise, I would say no later than 10 p.m.
All right. And Ms. Meyer, what are your thoughts on the timing?
I think the whole operation, and yes, alcohol, it shouldn't happen in the first place, because there's a problem, people drinking, and by supporting it, selling alcohol readily available makes the problem of alcoholism even worse. So I would object.
So for you, it's an outright. You're suggesting to us an outright refusal as opposed to limiting the times.
Yes.
Okay. And Ms. Osrin, what's your view on this subject?
Yes, I would love it to be turned down completely. However, on the same street, the Playground Theatre has a licence, I think, from 10 a.m. till 11 p.m. And with the development of the street, I think that, you know, there will be a need for licensed premises. So I would accept, I mean, with Mike, I would say it could be in line with the other licensed premises on the street and go till 11 p.m. That would be my preference.
Right, so we've got, I think we've got a 10 p.m. to 11 p.m.s and one outright refusal for the four of you, but recognising that there's 58 objectors and people will have different views. But
yeah, it's only my personal view.
I understand that, and that's very helpful to us. Let me just have a look at the other questions I've got before that. Let me turn to Councillor Blakeman, and I might come back and see if I've got something else.
Yes, I just wanted to ask you, given that there is already a 24-hour operation, I couldn't quite make out how disruptive it was overnight at the moment.
It's extremely disrupting. As we said, these petrol vehicles being driven from other premises to there, the general noise, they seem to have some alarm, like a ticking, ringing bell, that where they approach the building for some reason it sounds off, and it really is, the resident isn't present at the moment, no, but it's driving him insane.
Thank you.
Do we want to hear, Councillor Blakeman, do you want to hear from the other three objectors on that point?
Well, only if they wish to.
If they wish to say something.
Sorry, I forgot to put my hand up. It's Georgina.
Yes, please go ahead. Please go ahead.
There have been delivery lorries in the wee hours, delivery lorries, huge lorries. Because they were reason the engines were made, so fumes spewing out into the street, and one particular delivery took almost an hour with thundering engines in the middle of the street, not to mention doors of the lorry opening and slamming, trolleys being pulled across into the middle of the road with doors slamming from Gatir, loading of such goods onto the trolleys, and then bit by bit moving them into the building. I think that more or less sums up, you know, just one cause of noise and nuisance in the middle of the night.
Thanks, Miss Pomper. Miss Osrin, you've got your hand up as well.
That's helpful. Condition.
Oh, sorry. Yes, I was just going to say I do not live opposite the unit, but I know that everything works on its own and it's no precedent, but the granting of a 24-hour license to a small business unit, I just can't imagine that happening on a residential street, maybe elsewhere in the borough. I mean, I can't imagine why it's even been raised by Getir. It means that the small design office in the middle of big houses can now say, let's have 24-hour licensing for this property. I think it's a very slippery slope. Anyway, that was my comment.
Thank you.
Anything else, Councillor Blakeman, before I
No, that's all at the moment. Thank you.
Okay, thanks very much. So let me turn to Ms Titcombe and see if you have any questions for the objectors.
Thank you, Chair. None from me.
Mr Labar, any questions for the objectors?
None from me, Chair. Thank you.
Thank you. Mr Nixon, any questions for the objectors?
Thank you, Chair. I suppose there's a couple of points of clarification. Planning, we've touched, and that was addressed in the letter submitted.
are these
Sorry.
going to be questions? Because I'm not taking points of clarification. I mean, we heard your evidence earlier and we heard the evidence from the other side, but if you've got a question for them,
Sure.
please go ahead.
No, Chair, I think it's been covered in the case summary. I won't raise questions because it's already covered in the case summary and further submission, so I'll leave it there.
Okay, thank you very much indeed, Mr. Nixon. So if there's nothing else arising from, which there won't be because we didn't have any questions, that brings us to the end of the third stage, which is the objectors. The next thing we need to go through are the potential conditions. If the committee was minded to grant the licence, we'd have to consider conditions, and Heidi put up a there it is, it's going up on the screen now, a list of draft conditions which she needs to go through with the applicant. I'm conscious this process might take a bit of time to go through, and I'm quite minded to have a 10-minute break at this stage. So if we could resume at 12:05, please, that would be very helpful, and then we'll go through these conditions. So the hearing is now adjourned until 12:05.
Could I just ask, sorry, apologies, because I actually need to leave now. If that's okay, because presumably I would have no more communication in this meeting and I can watch it on catch up.
I think you can safely watch it on catch up. I mean, there is an opportunity to discuss the conditions, but most of them are quite technical. So I think personally, I think having done quite a lot of these, I think you're pretty safe to leave at this stage, Ms. Osrin.
Okay, thank you.
All right. We're very grateful for your participation today, though, and thanks very much. And for everybody else, we'll see you back at 12:05. Right, I make that 5 past, so I'll just look to governance to make sure everyone's back and that we're ready to restart.
Thank you, Chairman. It's Anne Wright here. I can see that Councillor Bateman is in the meeting. Can we just check your microphone's working?
I'm here. Can you hear me?
Yes, super, I can. Thank you. And Heidi, are you back?
Yes, I'm here. Thank you.
Super. Just to check that Mr. Nixon's back.
Yes, and the applicants are back as well.
Thank you. And the objectors that are still with us.
So, Ms. Pomper, you've got your hand up, and are
Yes.
you back with us? Yes, you are. Yes.
I am back with you. I just
We haven't. We're not live yet, so if you just pause on the whatever you've got your hand up for, you're back, and Mr. Riley.
I'm not sure Mr. Riley's with us, Chairman.
Okay, if you can carry on going around the others and perhaps come back to him, Anne, and let me know when you're ready.
Lovely. Can the other 2 objectors who are still with us, Anna, are you still with us?
Yes, I'm here.
Super, thank you. Oh, Mr. Riley's just in our lobby. I'll let him in.
I'll beat you to it, Anne.
Mr. Riley, are you with us now?
Hi, yes, sorry, I keep having technical problems.
Sorry about that. We can hear you clearly. Thank you.
Thank you.
Mr. Phelan, are you with us? Paul?
Apologies, Anne, I am.
Super, thanks. I think we're all here, Chairman.
Okay.
We're live, so you can just continue as normal.
Thanks very much indeed. That's
no problem.
So we're resuming the case of Getir Limited, and we're about to go on to the stage of going through the potential conditions, which the legal officer will lead. But Ms. Pompey, you've got your hand up, and let me take your question or your point.
Yes, thank you and apologies. Sorry, we were asked this question on the spot and I have had time to reflect. I would like to amend my earlier statement. I would like to say no to any licence.
So you've changed to an
Yes,
outright refusal.
Yes.
Okay, I mean, it's not a vote, it's just your personal view, and I'm happy
indeed.
that we've heard that. Obviously, the committee will have to come.
But that's my standing now.
Okay, well, thank you very much for clarifying that. And I will now ask Ms. Titcombe to go through these potential set of conditions, please, with the applicant.
Thank you, Chair. As this matter has come before committee, the committee can obviously attach any conditions they consider are appropriate and proportionate if they are minded to grant all or any part of the application. This discussion is not prejudging what the committee do, but it's important that in an open forum we discuss any potential conditions which have been suggested by the applicant, which have been suggested by the responsible authority and other parties. And I've produced this list from the submission that was served by Mr. Nixon yesterday, and also the 2 conditions that Mr. Labar wanted. So it would be helpful if they could both comment at the appropriate time. So dealing with the first condition, in Mr. Labar's representation, he has indicated that if this licence is, if the committee are minded to grant the licence, he would prefer that the alcohol should not be sold after midnight for the reasons he's given. So between midnight and 7 a.m. on Mondays to Sundays.
Sorry, Heidi, I do apologise. Could we go back to the page that we were on before and just keep it on there, the page of conditions, please? That's
Yes,
really
that-
helpful. Thanks very much. We just need to keep going down this page because we really need to understand these potential conditions. My apologies, Heidi. Go ahead.
No, that's no problem. And in fact, I have cut and paste from the main document, so it's all in this one document. That condition would not prohibit alcohol from being selected and boxed and bagged up between midnight and 7. If that restriction was on there. Mr. Labar, can you confirm that that is the sort of condition you were minded for the committee to have?
That would be perfect.
Okay, thank you. And Mr. Nixon, can you advise whether your clients, this is something that your clients would be prepared to accept, or any comments you may have?
Yes, Heidi, my reading is that deliveries of alcohol to the premises, therefore alcohol deliveries from the premises would not be restricted by this condition. Is my reading correct there?
Well, you've actually put a deliveries condition, is it 18? Oh, sorry, in relation to deliveries. So
the premises, Heidi.
Deliveries from the premises would be restricted.
That's not my reading of that condition. If that is the case, then no, the applicant would not agree. That would be a restriction on the licensable hours, which we would not agree to. My reading from that, Heidi, is to quote, collections of alcohol from the premises, not deliveries, or deliveries to the premises, not deliveries from the premises.
Yes, you're quite right.
If it was that exact reading, then yes, the applicant would be happy.
Yes, so you're quite right to identify the error in the drafting there. It should be deliveries from the premises.
In which case, no, we would not agree to that condition, as it restricts the licensable hours.
Okay, thank you. Moving on to the second one, Mr.
Sorry, Heidi, before we do, I know the Ms. Pomper's got her hand up, and I know that the objectors would also have a different view of this, and that two of them would like an outright refusal, but two of them would like different times. But we have, as a panel, noted that, and of course we'll have to discuss this and resolve this as a panel later on. And Ms. Pomper's put her hand down, so I think that was the point that she was wanting to make. Please go on to number 2.
Okay, yes, I am stressing that I'm not prejudging what the committee may do. Okay,
understood. Totally understood.
Yeah, so moving on to number 2, this is a condition that was suggested by Mr. Labar, and I have added in red some suggested amendments. Mr. Labar, can you confirm whether you want those amendments, whether you don't consider they're appropriate, and in particular whether you consider on the first line that the reference to a dispersal and an external management plan is the correct phraseology, or should it just be an external management plan?
I'm happy with the amendments that you've made, Heidi. They make sense. They address my concerns with regard to public nuisance, and I think that, they are very pragmatic. Thank you.
Okay, thank you. Mr. Nixon, could you please comment?
No immediate objection, just reading through it, and bear with me, Heidi, I appreciate it was only sent through this morning, so I've not exactly memorised these. The only issue I would have is the reference to the front door. We do have a side door that is in use as well, which I don't think is a detriment to the overall condition. So if that specification was taken out, not only that, there is hours of X. Heidi, what is the suggestion there, or is that for the council's decision?
Well, it was for you and Mr. Labar to make some suggestions, and then the committee can consider those.
If the front door provision was taken out, as I say, so we're not in accidental breach if somebody uses the side door. The use of electronic vehicles are ubiquitous anyway. Collecting deliveries from inside the premises, ubiquitous anyway. All the other times, I don't think we'll have immediate concerns with. So midnight for some continuity.
Sorry, so in fact, you're suggesting that you don't have the front door, so the deliveries are via the side door. So if one changed the word front to side, would that be better?
I mean, it could be both, Heidi. As I say, my main concern here is accidental breach rather than drawing a line in the sand. considering it would have no detrimental effect to the overall condition, maybe no specification, and that the fact that it will be conducted inside makes that kind of irrelevant.
Okay, Mr. Labar, did you have a comment on that?
That your suggestion or the suggestion made by Mr. Nixon at midnight would be satisfactory for myself. And also the use of the side doors, I would welcome that, because that would how can I say, again, assist in the prevention of public nuisance rather than coming out the front door, which is directly opposite the local residence.
Winston, I am suggesting no specification on which door is used. As I say, we'll use the most appropriate. It's just we don't want somebody walking in or out of one particular door and being breach of that through accident. Hence why I'm asking for no specification.
Mr. Nixon, how many doors do you actually have?
The front and side door, Heidi.
So if one put side and front, would that
that would be acceptable? That
would be acceptable. Thank you, because obviously you know the description of these premises. I don't, so it's important for you to fill these gaps in.
Appreciated, Heidi.
Yeah. Okay, that's fine. So number 3, Mr. Nixon, the reference to soft drinks. I think this is already covered by number 1 above.
I would agree, though. Again, my reading is collections. So from the premises, we don't have collections, so the condition is irrelevant.
Okay. Mr. Labar, did you have any comment?
That my comments were in relation to deliveries. Sorry, you say that there's no collections, so I may have worded that incorrectly.
Okay, so we can look at that. Okay.
Would the word distribution be appropriate, Heidi?
Yes.
No distribution of alcohol from the premises shall take place, but and then that's the I think that's the intention of what you've drafted there.
Okay.
Heidi, just to clarify, if worded as distribution, we would not accept. But I appreciate everything I say here in terms of not acceptance to the council's decision, but just comment there.
Yeah, we haven't made it. We have. I'm just made clear we haven't made a decision yet, but I'm just trying to get the intention of these right and the wording right.
Yes, thank you. So then the next sections from 4 onwards, these are the conditions that you put in your appendix at the back of your submission, which I've cut and paste and made a few tweaks. So number 4 is that no members of the public will be allowed on the premises.
Agreed.
Do you have any comments about number 5?
No, it achieves exactly the same thing. So no, agreed.
Okay. And then number 6.
Again, achieves exactly the same thing. Agreed.
Okay. And number 7 is yours. In terms of 8, you've suggested 3 bullet points for your CCTV condition. The council has a more comprehensive CCTV condition, which you're probably familiar with. Are you happy with what's in red if we replaced your 3 bullet points to the red wording?
My only concern or comment, I should say, is on condition F, that Metropolitan Police will be notified by email within 24 hours. Can I ask for the reasoning, Heidi, as we have no public access?
Yes, that's normally a standard requirement of the Metropolitan Police. So if the equipment is faulty, if something happens, the police and licensing authorities want to make sure that it's captured on CCTV, and there are often cases where operators don't have faults repaired, and this is there to prevent that sort of thing.
I mean, it's odd for a premises with no public access, but no immediate objection.
Okay, thank you very much. That's helpful. And then moving on.
Sorry, Heidi, just on condition H there, customers remain on premises, if that could be struck.
Yes, that should be deleted.
Thank you.
So the condition will be remain, but it just says it should be during all time the license is in place.
Open for licensable activities. Yeah, I see what you mean. Licensing place. Yeah, agreed.
Yeah. Okay. And then you've got to have a notice anyway once you operate CCTV, so that's presumably accepted. The amendments to 9, do you agree? I know you suggested the log.
G, seizures of drugs and offensive weapons. I don't think that's fairly appropriate.
That was in your suggested wording, I think.
Was it? In which case, I should scratch it. But either way, no objection, Heidi.
That's what I put it in.
Yeah.
Okay.
No, that's fine. That's absolutely fine.
Okay. Number 10, just a few tweaks there. Are they okay?
Accepted.
Number 11.
Accepted.
Number 12.
Accepted.
Number 13, you put the reference to delivery drivers shall conduct all deliveries in a manner. What do we mean by conduct?
I suppose we're talking conduct rather than conduct, if you forgive the pronunciation. Driver's behaviour, that they will not create noise disturbance.
Okay, so I can alter that. And otherwise, are you happy with the amendment to the next sentence?
Avoidance doubt not slamming doors. Could that be reworded?
It should be of doubt, not slamming.
Yeah, agreed.
Yeah. Then number 14 is your suggestion. Number 15, you've suggested collections of waste shall only take place between 9 in the morning and 8 p.m. daily. So I have just turned that around to say rubbish, including bottles or cans, shall not be deposited outside the premises between 8 and 9. And then the next amendment goes to that they shall not take place between 8 and 9, as you've suggested. It's just making the condition a negative condition. Are you happy with that?
The not being deposited outside, Heidi, that seems slightly heavy-handed at 2000, considering, recycling cardboard would be practically silent. Is there any chance we could agree that that will be later on, maybe 2300? Well, again, I'm pointing to the recycling of cardboard, really, and just taking that out so it's not accumulating.
Well, our more standard wording does say 23, but as you'd put 8 o'clock, I just adopted your hours.
Yeah, I appreciate it for continuity. Yeah, and I can see why you've done it.
But if you want 23, I can put that in, and it will be for the members to consider.
I would agree to that. I mean, any noise will be from the actual collection by our waste management providers, not putting cardboard in a bin. Yeah, so yeah, if that was changed 2300, agreed.
Okay, and then I've got your 8 and 9, and then number 17. This was your suggested management plan, but I think it's been superseded by 2. Yeah,
I'd agree.
Again, number 18, I've adopted the hours you've suggested, which this is your wording, saying deliveries of goods to the premises shall only take place between 9 a.m. and 8 p.m. So I've just made it negative. Are you happy with that?
Actually, Heidi, I'm more content with condition 1 as it's worded now. I appreciate that might not be your intended wording, but considering that relates to alcohol products only, I would like that amended to read deliveries of alcohol to the premises, as that will be more appropriate to the license and the licensing objectives for the supply of alcohol. So yeah, I would ask amended to read exactly like condition 1. Exactly like condition 1.
This is more general deliveries. This is not.
Hence why, I'm disagreeing now. I think yours is more appropriate as worded by condition 1. In which case, I'd ask it to be replaced word for word with condition 1.
So you want to limit your own condition to alcohol?
I think you've worded it much better than me, because that would make it relatable to the licensable activity that's taken place, which is alcohol. So I think actually your wording of deliveries of alcohol to the premises should supersede 18 word for word. I think that's far more appropriate.
Okay. Then 19, 20 and 21 are all yours, your suggested wording. And then 22, you've suggested a training condition, and you've mentioned during your submission how you take training seriously. The council would normally have a training condition which is reflected by little point 1 and 2. Are you happy for this to be replaced?
Achieves the exact same thing. Yeah, agreed.
Okay, thank you. And then we've got your challenge 25, which we'd suggest again that we would change it with our model condition on that.
Again, achieves the exact same thing. Agreed.
Okay. And then in terms of refusals, that's your condition. The committee may well then want some additional conditions of their own, and one, if there are residential objections, as there are in this case, they would often ask for a dedicated telephone number to be available.
Agreed.
Yep. Then the number 26, no deliveries are to be dispatched from the premises unless a valid registered address has been given. I think you confirmed that was the case.
Yeah, I mean, it doesn't relate specifically to alcohol, Heidi, but that's how we operate. So, yeah, relevant, agreed.
Well, I think it goes to the verifying identity. That's why. And yeah, then you've suggested that you would accommodate some meetings with residents. I've suggested twice a year.
Yeah, if that works for the residents, I'm happy to commit to that.
And would you be willing to notify particular residents, or are you suggesting that you would contact residents' associations?
I mean, I'm aware the Latimer Road residents have alluded to that they are part of an association, and that would be, I would agree, that would be highly appropriate. I would be happy to be steered by them in terms of a contact list, that they would be far better to circulate than us in terms of interested parties. So in those interests, yeah, absolutely. Local residents, as long as I'm provided at first instance upon grant of the license, the relevant contact details, they will all be included, and I'm happy to expand on the list. So yes, agreed.
Thank you. It might be appropriate then to ask the residents at that point what they would suggest in terms of that condition.
Given their track record at the moment, I would suggest far more frequent than twice a year.
Right. How more frequent?
I would suggest something like quarterly, or even by every couple of months.
I would agree to quarterly, Heidi. A couple of months, sure, I'll be open to it, but I don't want to be too much of a burden to the residents that every 2 months they have to see my mug. I think quarterly would be acceptable.
Okay. And Mr. Riley, do you want Mr. Nixon to notify you, to send a letter direct to you, or are you happy for the...
He has the contact numbers of all of our steering group, actually. Contact all of us.
Email, I'm happy to do. Mike, would that work for you?
And what is your steering group called?
No problem.
For the
Latimer Road Preservation Society.
Sorry?
Latimer Road Preservation Group.
Yeah, I'm happy with that, Heidi.
Okay. Thank you very much. And then
I think we need to hear from the other residents on this as well. So I think Miss Meyer's got a hand up, and we also need to know what Miss Pomper thinks as well. So Miss Meyer, perhaps you'd like to chip in here.
Yes. Can I go back to another points back, or did you want to go through and then I go back to a point? I want to go back to number 11 and number 25.
Let's deal with 27 because we're talking about that at the moment, and then we can go back later.
Thank you.
So do you have a view on number 27?
No, not at the moment. When we go back, I will comment.
Ms. Pomper, do you have a view on 27?
I'm happy for quarterly meetings, but I do have comments on other points. But I'm happy with quarterly meetings.
All right, we'll go back. Let's press on then beyond 27, and then we know we've got to go back and get
Okay.
on a couple.
And then 28 is to ensure that the staff smoke in an orderly manner. What number? How many staff were you prepared to limit smokers to? You said they normally have 1 or 2. Would you limit it to 2?
Gavin, could you comment here that we are happy to maintain that only 2 persons? I mean, that would be sensible. Are you happy to agree to that?
Yep, I'm happy to agree that there will only be 2 people outside of the premises smoking at a time.
Thank you, Gavin. Yeah, agreed, Heidi.
Thank you. And then what about the condition 29 about super strength?
Agreed.
Okay. And the noise of plant?
Yeah, we have nothing like that. Agreed.
Okay, thank you. And then I don't know if members wanted to suggest any other conditions or...
I think we've covered. Just bear with us for a moment.
Yeah.
No, everything on my list I think has been encompassed within that. So as expected. So you just let's see if Councillor Blakeman is content.
Yeah, on condition 27, I think you should include the St Quintin and Woodlands Neighbourhood Association and the St Helens Association.
St Quintin's and
Woodlands.
So sorry, I didn't catch that.
Woodlands.
Oh, Woodlands. Sorry.
It's yes. So we noticed one of the local RAs.
Okay, thank you.
I think
Yeah,
we may
no
object to
objection,
that
Heidi.
grounds that they are not living within the vicinity.
Well, a lot of them have submitted objections to this from the Woodlands area, like Ms Meyer, for example.
Okay, I'll have to speak to the others. Thank you.
Okay.
Ms Meyer has a hand up.
Yeah.
Yes, one point which I don't think it was covered is there a supervisor 24 hours on the premises? Or is it just staff behind the scene?
No, there's a supervisor on premises, Anna.
So Gavin will be there 24 hours, having come back?
No, he's the site manager. There are other supervisors.
But people in charge? Because it's
Yes,
not speaking each week to a different person if something arises, which can be very tiring for residents, I tell you that.
We're straying into comments here when we're talking about conditions. So I think.
Yeah, sorry.
I think we know that. So let me clarify this with Ms. We're saying from Mr. Nixon that there'll be a designated site supervisor in place at all times that the place is open. Is that right?
That's correct, yeah.
Thank you. Okay, let's Heidi, back to you, please.
Thank you. I think I'm finished, but subject to what the objectors comment.
Yes, they do have some comments. So I think which one was it? I think it was Miss Pomper. I think you wanted to go back to some, and so Miss Meyer did as well. So there's no hands up at the moment. So Miss Pomper, you wanted to go back to 11 and 23, I think. Or was that you, Miss Meyer? Miss Meyer, your hand's up. So you go ahead then, Miss Meyer. You've got your hands up.
Which comes back to the supervisor as well. Point 25, the phone number, a designated phone number, 24 hours. So basically, if something happens, sorry.
No, it's fine. I was muted. Yes, the phone number is to a site telephone. Therefore, anybody
Answer phone.
No, site telephone.
Manned, womaned telephone?
If manned, then yes, of course, it'll be answered.
No, but quite often it just goes to voicemail and then it's not. So I think it should be phrased a bit better.
I'll go back to Ms. Titcombe there on that one.
Yeah, I'm happy to take advice on that, Chair.
Well, I mean, the whole purpose of number 25 is that you do have, as Ms. Mayer has said, that if they ring up, they don't want to get they don't want to get an answer phone, because if there is noise occurring, they want it to be addressed at that stage. So the number that you give would have to be a number, but obviously this condition would only apply whilst the premises are open.
20 hours, yes.
So if the members don't approve the 24-hour operation, then they wouldn't be required to have their telephone available 24 hours.
Fair enough. Okay, but if it could be worded, whatever is the outcome.
Okay, we can look at that.
It makes sense. The next point is number 11.
Yes.
Refuse a delivery when customer is drunk. Now, considering the alcohol being ordered in the middle of the night, it's not someone who just comes home and thinks, oh, I haven't got wine. It's someone who stocks up, but I mean, that's my own. So basically, the Get Here driver then has a look at them, gives them a breath test and says, sorry, you're too drunk, you can't have my alcohol, and takes it back, or... Especially drugs is another concern. I mean,
unfortunately, Miss Mayer, the licensing operators are not police, so they can't demand people provide breath tests
and
things like that. All they can do is a subjective assessment as to when they're delivering the alcohol, whether they consider that person is under the influence and therefore they shouldn't be supplying the alcohol to them. That's a common requirement in all licensed premises.
Can Chris clarify this a bit?
Mr. Nixon, I don't know whether you want to comment further on that, because
no, just in agreement, Heidi.
You're the people who are trained the drivers.
Yeah. In agreement with exactly what you've just said, Heidi.
Hello?
Sorry, is that working now?
Yes, we heard you, Mr. Nixon. Yeah.
So, yeah, in agreement with what Heidi's just said there. I've got nothing else to add there.
Thank you, Ms. Meyer.
Ms. Meyer, this is a condition that's suggested by Mr. Nixon.
Yeah, but how will it be enforced? Or is this just goodwill of Getia?
Mr.
Chair, I'm not sure if it's just me, but I'm not picking up Heidi's microphone.
No, I think you're right, Mr. Nixon. I didn't hear Heidi at that point. Ms. Titcombe, can you hear me now? Have we all frozen up?
I can hear everyone, but there is a bit of interference. So people are dropping in and out, but right. I think I can hear you again now.
Yes, Ms. Titcombe, I think that's your end, I'm afraid, because you dropped out a moment ago when he was speaking. So if you could perhaps repeat your point about number 11.
Yes, certainly. Number 11, if you can hear me, was suggested by Mr. Nixon of the so that this is a condition that's been suggested by the applicants, and Mr. Nixon can explain how they train their staff to ensure that they're not providing alcohol to drunk people, as any licensed operator would. So perhaps, Mr. Nixon, you would like to comment on that.
Of course, pretty much exactly as you've just described, Heidi. The training course that our staff go through is that they make an assessment of the customer that the order is being made to, just like any licensed premises. If clearly under the influence, then the order is refused. Again, exactly as any other licensed premises.
The order or delivery?
Ms. Meyer, just hold on a moment. Mr. Nixon, have you finished your point there?
Sorry.
No, I haven't finished yet.
Okay, thanks. So, Mr. Meyer, I mean, this is a condition suggested by the applicant. Would you rather it was not in at all, or would you rather it was in as worded, or have you got a different suggestion?
I just want to know what it stands for, how it will be enforced.
Right, Mr.
Because I've been living in Camden for 30 years, and basically bar staff is not supposed to serve customers who are drunk. I mean, they would lose half their trade. So I don't think it's a.
I'll allow, because we could be here all day discussing that particular point, because what is and what isn't drunk. But I'll allow Mr. Nixon to come back once more on that, and then I think we'll have to move on, and the committee will make a decision on that when we retire.
Okay, thank
you, Chair. I'll keep it brief then. That I can't comment on premises in Camden, but that is exactly what our drivers are taught to do. If someone is clearly drunk and it's not that difficult to identify, then yes, they would refuse the order of alcohol and it would be taken away. It's how they're trained, and that's how we operate.
Okay, thank you for that, Ms. Meyer. Are there any other of the potential conditions that you want? 28. Okay, let's scroll down to 28, please.
Orderly manner. Now, if a couple of people standing on the street at 3 o'clock at night, chatting away, in the bedroom opposite, it's like they're sitting on the edge of the bed. Especially if the street is quite apart from Getier's delivery area. And I think there shall be no hanging around outside after a certain time. If it's a business, I mean, if they're private people walking down the street, fair enough. But if it's a business, this should be in the conditions.
I think this is slight. Sorry, you may be having difficulties hearing me. I'm going to try and hold on as long as my internet allowed.
Keep going, Heidi.
Yeah. So in terms of smokers, they have to be outside by law. So people have to be able to be outside smoking. The operators here have suggested that they will limit the number of smokers to 2, and I will amend this condition to reflect that, and that they will monitor them. They have CCTV, so if there are problems, the managers can deal with that. And if residents feel that they're not dealing with it appropriately, then they can raise it with the applicant. But these are matters the committee will consider, all the points you've raised, because it's not an exact science, these things.
Thank you. Okay, thank you very much.
Mr. Riley's put his hand up on this point. So, Mr. Riley.
Yeah, I mean, a lot of the other units have access to the rear overlooking the railway viaduct. Can that not be an option for a smoking area?
Let's hear from Mr. Nixon and see if the rear of this building is available. It wasn't clear from the outside whether it is.
Chair, I'll direct to Gavin. Gav, could you confirm whether that would be appropriate or not?
The rear of the building in our specific unit is the back is directly onto the fence.
So no. Okay.
Thank you, Gavin.
Thank you. We've noted that. So are there any other points or any of these potential conditions that objectors wish to discuss? I will just hold for a moment and put your hand up, please, Mr. Riley.
Yeah, I'm led to believe there's a 2-metre gap at the back, which is a regulation of Network Rail. So being backed onto the fence, I don't think it's quite true. There's a 2-metre gap.
Right, well, we'll note that observation. Thank you. Are there any other points on the potential conditions from you, Mr. Riley, or anybody else? And we'll say no. Okay, well, thank you very much, Mr. Nixon. You have an observation to make?
Just, Chair, that regarding the conditions about restriction on hours where alcohol is not concerned, and also the general 24-hour licence, yeah, our comment is we don't agree, and we think that's addressed within our case summary, which I'd like the councillors to consider.
We'll be considering all the points put to us today by both yourselves and the responsible authorities and the objectors. And
thank you, Chair.
when we come to our right, well, in that case, I think we've come to the end of considering the conditions. Are there any other points from the legal officer, Ms. Titcombe?
No further points from me. Thank you, Chair.
Licensing, Mr. Phelan, any final points from you?
Nothing further from me. Thank you, Chair.
Okay, thanks very much. I'd like to thank everybody for making your representations today. The panel will now retire to make our decision. We won't be reassembling today. Governance will notify parties of the decision within 5 clear working days of today, and the full written determination will follow later on. So thank you all again. The hearing is closed. The live stream broadcast will end, and the panel will meet in our private Teams room, and then we'll decide what time we're going to resume after lunch. So thank you all very much.
Thank you very much.
Thank you, councillors.